Welcome to session 2 of the Succession Law and Elder Law series, which Michael has put together. And I was very pleased to accept Michael's invitation to act as chair this morning. We've got 2 very interesting topics this morning, and I'm looking forward to hearing the papers being presented by Simon Pitt and by Peter Pascoe. First person up is Simon Pitt. Simon came to the bar from Herbert Gear in those days, in 2003. He's particularly interested in matters involving Corporations Act, wills and estate matters. He has developed a very keen interest in lecturing and teaching. He's been active with the Victorian Bar Council, being Honorary Secretary for a number of years and also a member. And he has formed and is now chairman of the Victorian Bar Student Engagement Committee, which is dedicated to increasing the awareness of secondary and tertiary students of the bar as a career path following the study of law. Simon, I invite you to present your paper on family provisions. Thank you.
Good morning all. Thank you for coming along bright and early. And this is an interesting topic indeed. It's one which we've probably all got a relatively good level of familiarity with, Part 4 of the Administration and Probate Act and the blueprint for reform, which is set out in the Victorian Law Reform Commission report, which was released late last year. As most of you will be aware, there was a consultation paper which was circulated in late 2012 about the possible areas for reform in this in Part 4 cases. The Commission in its inquiries identified that there were a number of concerns with the way the law is currently operating, including a belief that the current law encourages opportunistic or non-genuine claims, that there are there's high legal costs which are borne by the estate in these matters, and there's a large degree of public displeasure with that, and the lack of oversight that the courts have in relation to these opportunistic claims because of the fact that most of them, about 95%, settle at mediation, and the lack of certainty that exists in the jurisdiction because of the way the law is currently framed. So what I'm going to do is just quickly go through the Law Reform Commission's report and just take you through some of the areas which have been recommended for change. But basically, there was a wide divergence of views in the report as to the way the law is currently operating. Some people, including some eminent practitioners, actually feel that the law is working quite well in practice, and that this perception that there's opportunistic or non-genuine claims is perhaps being beat up a little bit. And other commentators have described the legislation as being a blueprint for bludgeoning, and that avaricious children, nosy neighbours with an interest in the next door neighbour's estate and so forth, are just throwing spurious claims at the wall to see if something sticks and see if they can get some money at mediation. Whichever way you look at it, Part 4 is a growing area of the law, and I've often reflected on the reasons why that's so. I think a combination of compulsory superannuation, the Australian dream of owning your own home, and financial difficulties that have been experienced perhaps in the last few years because of the rising cost of living or the global financial crisis, and so forth, as well as the expansion of categories of claimants post the 1998 reforms to the Administration and Probate Act, and as I said before, maybe just a little bit of avarice, and you've got a recipe for a good busy legal practice there. So there's no doubt that there are a number of claims coming through. There were 489 Part 4s issued in the Supreme Court of Victoria in 2011, 2012, and 168 issued in the County Court of Victoria. So on any view, that's quite a big number. So I think there are a number of reasons why this is a growing area of law, and it's good for us, but we need to know of the changes that are in the wind, and to that end I'll take you through some of the proposed reforms. So the first real reform topic was the question of jurisdiction. As I said, there are a smaller number of claims being issued in the county court as there are in the Supreme Court. The county court feels that it has capacity to hear more of these cases, and the Supreme Court feels like, particularly the associate justices, feel like they're being overburdened with cases that are being issued for small amounts of money. And some of us, that's interesting, some of us will have seen claims for $100,000, $200,000, $300,000, and we all know that the costs of running these matters, by the time you get to mediation, assuming costs are $20,000 aside, sometimes more, that can very quickly eat into the estate and represent a significant proportion of estate assets. So the county court wants to be more proactive, and they want to get a number of these matters in and deal with them expeditiously. And the profession and the judges seem to have backed that position up. So there was quite a strong support for giving the county court an exclusive jurisdiction for matters $500,000 and less, and that was in fact the first recommendation that the Commission made. So it seems that for those of you who've run cases in the county court, it's Judge Misso's list. They are run quite quickly. There's a bit of a rocket docket. You've got usually a judicial conference as opposed to a mediation or a compulsory conference where the judge gets you in and goes through it all in a pretty sort of streamlined way. You can have a private mediator, of course, but they encourage this the use of the judge. So that was the first recommendation, to grant the county court exclusive jurisdiction. And as to the rest of the cases, the county court and the Supreme Court already have and will continue to have unlimited jurisdiction in the civil area. So you can still issue in the county court for, however big the estate is, if you like. But there is a bit of a reluctance. Some of the voices within the report felt that because of the Supreme Court's natural connection to probate, because it's the court that grants probate, a lot of purists, a lot of traditionalists feel like these matters belong in the Supreme Court, and there was a bit of a feeling of that coming through in the report. But assuming the Commission's recommendations are accepted, we could see the county court having exclusive jurisdiction for matters under $500,000. Next is the question of eligibility, which is a big one. At present, and post, can you all hear me over that? Good. Post the 1998 changes, of course, you had an expansion of the categories of people who can make a claim under Part 4. It used to be limited to spouses and children, and it's now basically open to anybody to make a claim under Part 4, as long as they can satisfy that three-stage test that the court has enshrined. And the three-stage test, just to briefly recap, we've got a criteria-based system. First is whether at the date of the deceased's death, the deceased had a responsibility to make provision for the proper maintenance and support of the plaintiff. The second is whether the distribution of the estate by the will does not make adequate provision for the proper maintenance and support. And if you clear that hurdle, third and last question is the amount of provision which should be awarded. So assuming you can clear those three hurdles, it doesn't matter whether you're a neighbour or a step-grandchild or a second cousin twice removed, the legislation is available to you. Victoria is the only state in Australia out of all the states and territories that still maintains such an expansive operation of the family provision legislation. All other states and territories have moved towards a status-based or a list-based system where there's a bit more of a sort of a codification of persons who can make a claim. And there was a lot of debate about whether Victoria's method is right or wrong. Some commentators said that Parliament has struck the right balance because Courts are very well equipped to deal with these cases on a case-by-case basis, dealing with the facts, working out if somebody is eligible for provision irrespective of their relationship to the deceased. And indeed, those of us who run these cases know how fact-specific each case is and how much each case turns on its own facts. And other commentators rejected that and said that this is the very piece of legislation which is encouraging spurious and non-genuine opportunistic claims because it's open to anyone. So there was a bit of an argy-bargy in the report about that, and a lot of people made some very interesting submissions. The Commission has come up with a bit of a hybrid as a recommendation. They do recommend a list-based type approach, but with a bit of a twist. So what does that mean? It's slightly more prescriptive, so you'll have enshrined in the legislation, assuming the Commission's recommendations are accepted, you'll have spouses and de factos and children as the three core eligibility criteria. But you've also got ex-spouses, got grandchildren, but the grandchildren have to have been dependent upon the deceased at a point in time, whether it be presently or in the past. And you've also got an expansion of that to cohabitants, that is people who are living with the deceased at any time, present or past, and were dependent upon the deceased. So that opens it up to anybody, whether they're a friend or a step-grandchild or anybody really, but as long as they can clear that hurdle of being dependent upon the deceased and having lived with the deceased. There's also live-in carers, so persons who've lived with the deceased in a registrable caring relationship, that's the terminology that's being used, and stepchildren as well. So it's a codification of persons who can apply, and in relation to D, E, F and G, which is ex-spouses, grandchildren, live-in carers and stepchildren, there's another hurdle that the Commission proposes, which is having regard to all the circumstances of the case, there are factors which warrant the making of the application. So that will be another test that an applicant has to satisfy. So if they fall within those bottom four categories, they will have to jump that extra threshold. Again, just a couple of comments and observations in relation to the proposed changes. The first thing that jumps out at me is that if those changes are accepted, it will have the effect of shutting out people who have been successful under the current regime. So people will fall at the first hurdle, such as step-grandchildren, siblings, nieces, daughters-in-law, friends and neighbours. And claims by all of those class of people have been successful in Victoria between 1998 and today. So some commentators say that that's an unfortunate consequence, and that the fact that those claims were successful demonstrate that the court is very well equipped to deal with claims by anybody as long as they can satisfy our current three-stage test. So those people would be shut out. And in the paper that I'll circulate by email later, I've just included a grab from the Attorney General, the then Attorney General Jan Wade, when she was giving the second reading speech in relation to the 1998 amendments, and it's quite instructive, and it's actually quite it's very the rationale and the underpinning for broadening the class was, in my view, very well thought out. So it was designed to give the court the power to determine cases on a case-by-case basis. So you can read about that in a minute. But for my view, I think that the current system is probably operating quite well. And I think that the perception that there's a number of opportunistic or non-genuine claims is probably a bit overplayed. and it can be addressed and should be addressed better by costs consequences, which I'll come to now. So that's the recommendation in relation to eligibility, and the next thing I'll talk about is costs. This was one of the biggest focuses of the report, and it's one of the biggest, obviously the biggest driving factors behind change, because particularly at mediations, the concerns about the increased costs of going to trial, the concerns about the costs already incurred, the fact that they will all come out of the estate is, as we all know, a very powerful motivator for people settling at mediation, particularly estates. They want to throw some money at the problem to make it go away so that they limit the amount of costs that are gouged out of an estate, and they get rid of that uncertainty of going to court. Because as we know, in these cases, you could probably have 50 judges hearing 50 matters and you would get 50 different results and none of them would be wrong. So there is a huge variation in decisions, and certainly a lack of certainty about, there's a lack of certainty about the outcome, and that operates very heavily on people's minds at mediation, in my experience. So there is that, the Commission in its report identified that the biggest concerns were there's a perception that costs usually come out of the estate, and there's insufficient deterrence for people making unmeritorious claims, and in this sense the costs law in Part 4s does not accord with community expectations. So the recommendations, just to briefly summarise, of the Commission were to replace the current costs provisions in Section 96, subsection 6 and 7 of the Act, with a provision that states that the court has the power to make an order for costs that is, in the court's opinion, just. So you can't get any broader than that. And setting out a non-exhaustive list of the types of orders which might be made, such as each party bears their own costs, the estate pays the costs, or indeed unsuccessful plaintiff pays the estate's costs. And thirdly, that the court be given the power to cap costs. And this has been, when I've been talking to practitioners in this area, that's been something which has gained quite a lot of support, to give the court the power to cap costs and indeed enshrine that in legislation. But just pausing there, there's a number of recent decisions which some of you will be aware of, which actually go to show that the court already has the power to do all this. Section 24 of the Supreme Court Act is obviously the section which deals with the court's power to award costs, and it's as broad as a house. The court has the power to order pretty much whatever they want in relation to costs. It's a discretionary matter. It's pretty much unfettered. We all know how difficult it is to appeal a costs judgment. So I'll just take you through three key cases which I think underscore that point and just go to show that perhaps the need for change on costs is not necessarily a task for the legislature, it's a task for the judiciary, and indeed the judiciary are making those noises loudly. The first is a case of Cangia, C-A-N-G-I-A, and Cangia, which is a 2008 decision of Justice Whelan. And in that case, Justice Whelan actually did cap costs. He capped the costs at $30,000 aside in an estate which was worth about $360,000. So perhaps he was being quite prescient there, and he was ahead of his time a bit. But there is authority for the proposition that the court can cap costs in Part 4s. So that's already able to be done. Secondly, the decision of Khan, Mirth and Mirth, which is a decision of Associate Justice Gardner, which you might be familiar with. And in that case, His Honour went through a number of authorities and decided that an unsuccessful plaintiff should pay the costs of the estate of the proceeding on a party-party basis. And that decision sent a bit of a shockwave around the practice area, because it was really Associate Justice Gardner sort of brought into play and voiced a number of the concerns that the public has about this. So that is an authority. It wasn't successfully appealed. that is an authority for the proposition that an unsuccessful plaintiff can pay the estate's costs in a Part 4. And that's a 2011 decision of Associate Justice Gardner. The third and final case that I'll refer to is Webb and Ryan, which is a 2012 decision, again, of Justice Whelan. And in that case, Justice Whelan had a close look at Section 96 of the Administration and Probate Act, and he made a few very good pronouncements and observations about the way those sections operate. And he makes the point clear in his judgment that the sections of the Administration and Probate Act do not confine the Supreme Court in the range of orders that it can make. And he refers specifically to Section 24 of the Supreme Court Act and confirms that the court must exercise its discretion and make an order for costs that it considers just in all the circumstances. And he does note that family provision cases are different in some respects in the way that they run, but he considered that the tendency to move towards the application of general cost principles whilst recognising the special characteristics of family provision cases where they are relevant is a sound and sensible approach. In other words, this isn't a job for the legislature. The current law is perfectly flexible enough to be to be able to be moulded into whichever form of order you like. So that's probably all I need to say on costs. There is a recommendation that the law be changed, but in my view, particularly having regard to some cases, recent cases, it's not necessary to do so. There are a number of other procedural recommendations in the Commission's report, and the first was for pro forma affidavits. Now, we all know, having read Part 4 affidavits, that some can be just a cathartic brain dump of every single fact since the person was born until the deceased passed away, and full of hearsay, full of submissions, full of everything they can think of in the hope that, you know, a section or some of those facts will actually be relevant. In my experience, mercifully, those affidavits are perhaps, they're in the minority, and people who practice in this jurisdiction, they know how to draft an affidavit, and they know that they have to have regard to those sections in 91 sub 4 in order to get an application over the line. And there is a noise that the Commission's making about directions as to length and form of affidavits and putting in the practice notes, what has to be contained. They may well make that change, or that may well be brought up into the practice notes of the Supreme and County Court, but it's certainly a perception out there that a lot of these affidavits are full of rubbish and just cost way too much. So it might be that perception is too hard to dispel, and the legislature sees fit to address that. So I'm not sure what's going to happen there. There's also a suggestion that there be guidelines as for when the matter will be referred to judicial mediation. At present, particularly in the Supreme Court, usually small estates are good candidates for judicial mediation. So $200,000, $300,000, $400,000 estates, the Associate Justice will usually say, one of two things: either do you want an Associate Justice to mediate, and do you want to do that before or after affidavits? So what we're seeing now is smaller estates being mediated before affidavits are put on. That saves the estate cost, and it hopefully disposes of the matter briefly because, as we know, about 95% of these cases settle. So that's interesting, that may well come through. Another interesting one is summary determination for claims under $500,000. They've got this in South Australia, and summary determination is basically, it can be made by an Associate Justice. The procedure is entirely flexible. It might be on the basis of evidence which is not in accordance with the rules of evidence, so no affidavits, and it has the primary object of minimising costs. So that will be an interesting development to see if that's introduced. The last thing, I'm conscious of time, the last thing I'll refer to which has been put forward in the Commission as a possible change, is giving people the opportunity to apply to court to release their rights under Part 4. And in my view, this is a fantastic initiative if it's brought up, because it gives families the ability to arrange their affairs while the person is still alive. So particularly with family farms and families where you've got a situation where the estate, as it will be, is asset rich but cash poor, they can make a family arrangement and the sons and daughters or beneficiaries can actually apply to court to release their rights to make a Part 4 claim after the testator has passed away. That imports a level of certainty into family arrangements, and it means that family farms and so forth are a lot safer, because we all know that a claim made on a family farm can be disastrous, because if the family farm and the children who are beneficiaries don't have the ability to raise the money to pay out the claimant, well, it's an unfortunate result that the land will be sold. More often than not, the family farm can be broken up and in some cases lost. So there is a recommendation in the Commission's report that this be introduced. There are quite a few strict criteria on the person making the application. They have to have received independent advice. It has to be just and fair and reasonable in the circumstances, and the court will have a close look at the situation before they give that person the green light. And 2 non-reform areas: time within which to bring an application, that's currently 6 months under Section 99, that won't change. And notional estate provisions, which you've got in New South Wales, where you can claw back assets that have been distributed into Vivos in certain circumstances back into the estate for the purposes of distribution to beneficiaries. The Victorian Law Reform Commission feels that that is probably not right for Victoria, and so don't expect to see notional estate provisions make their way into our law anytime soon. I think I'm right on half an hour, and so I'll hand over to Peter, and there'll be questions at the end. Thank you.
No, before that, we're going to ask, are there any questions of Simon?
I beg your pardon, sorry.
Before we go for a short break. Can I ask one? It's in relation to the mediations without affidavits. There's a school of thought there that if they're unsworn, they don't carry the weight of a sworn affidavit, and therefore there can be facts not truly put to the test. Have you experienced anything in that line?
I have. I've experienced unsworn affidavits. You're right, they don't tend to be treated seriously in mediation because they don't carry any gravity or any force. I think that in my experience, whilst they're treated with caution, you know that if the matter doesn't settle at mediation, the person's just going to go straight out and swear that affidavit anyway, and it's usually because of a lack of time or disorganisation or perhaps even laziness on the part of the parties, that affidavit hasn't been sworn by the time of mediation. So I think that, but I think the real point is that if you have mediations where there's just position papers or not even sworn material, how can you take anything seriously? Well, that's a real concern, and I suppose we'll just have to see how that one plays out. But you would hope it would be up to the mediator and the counsel and the solicitors to help the parties get through that and sort of, I suppose what I'm saying is if the parties are in mediation and it's without prejudice and it's a gloves-off approach, well, you would hope that what you're being told is true. So I think it's really up to the lawyers in that circumstance to make sure that the facts being put forward are true and that they've got proper instructions from their client.
Any other questions, Simon? Just another one from the chair. Have you heard whether, in relation to proposed legislative changes, whether there's anything on the agenda in relation to this report?
That's a really good question. I've made a few inquiries, and I've looked at the list of bills currently before Parliament, and I've put my ear to the ground and tried to find out what's happening. But as far as I can tell, there's nothing happening, and it's hardly surprising given all the other things that are on the Victorian State Government's plate at the moment. And in particular, maybe at the front of their minds is a very real concern about whether they're going to be there after November this year. So the short answer is no. I don't think there are any. There's no positive steps that have been taken in Parliament to enshrine any of this into legislation, and I doubt we'll see it this year.
Thank you, Simon.
Does anybody else have any questions?
If not, thank you very much, Simon. If you can please show your appreciation in the normal manner.
Thank you.